All right. Well, welcome everybody. Um, Welcome to ARA's Continuing Education Series webinar for October 2024. My name is Tony Saramatis with Truly Wow. We are ARA's marketing and communications partner, and we're excited to be unveiling the newly minted contract template for ARA members today. And we have Patrick Dunleavy, ARA's Contracts and Insurance Committee Chair. Um, Mike Poplinski was scheduled to be a host with us, but he's traveling, so he's going to be joining us um, anonymously. And so any insurance questions we'll have to come back to after the fact. And then, of course, we're joined by our friendly neighborhood attorney, Patrick Newman with Bassford. Real quickly, before I hand things over to Patrick Dunleavy to kick us off, just a couple of real quick housekeeping items. First off, I've got everyone on mute so we can keep the background noise to a minimum. We're going to save some time at the end for Q&A, probably 15 or 20 minutes. If you've got a question, go ahead and type it in the Q&A box at the bottom of your screen, and we'll keep track of them. And we'll get them answered in the order in which we receive them when we get to the Q&A portion at the tail end of the presentation. So now I will pass the baton over to Patrick Dunleavy to get us kicked off. Patrick, it is all yours.
Yeah, thank you, Tony. Good afternoon, everyone. Just want to say thank you all for being here today. As Tony said, my name is Patrick Dunleavy, and I am the chairman of the Contracts and Insurance Committee. On behalf of our committee, we are very excited to introduce a new contract template specifically designed to meet the evolving needs of our industry. And this template is the result of extensive research and collaboration with legal experts and industry professionals to ensure it addresses the unique challenges we face. The goal of this new template is to provide a comprehensive and flexible framework that standardizes key contract elements while also offering room for customization. It includes clear definitions to avoid ambiguity, detailed comments on each section to guide your decision-making, and highlights key specific areas where extra care and attention should be given. These areas are crucial for mitigating risks and ensuring all parties are on the same page. As we go through the presentation today, I encourage you to focus on these key areas of consideration and think about how they align with your own experiences and needs. Your feedback will be invaluable in refining this template for further ensure it serves our members effectively. Let's dive in and take a closer look at how this contract template can be a powerful tool for us moving forward. And without further ado, I'd like to introduce Patrick Newman to present to you our new contract template. Patrick?
Thank you, Patrick Dunleavy. Thank you to the ARA for having me, and I appreciate all of you joining us this afternoon to talk a little bit. You know, it's not always the most captivating subject matter, contracts sort of 101, but that is sort of the lens that we used in working on this this template document. At least for me, when I was in law school, they use a really weird way to teach us about contracts. You're like reading all these cases from hundreds of years ago to learn these principles, and I kind of wished someone would just show me a contract and just say, hey, what is this? Why does this exist? Why is this important? How can it be changed or modified? And so work together with the contracts committee to put something like that together. And because I guess you know, with apologies for being the lawyer in the room, a couple of just caveats to share with all of you. First, about this presentation, I am a lawyer. I'm not your lawyer today, so I'm not giving anybody legal advice, of course. I got to consult with counsel about that. We do find ourselves giving a lot of contract advice in this space, so that's something that can be done. It's just, this is not it. Also, the template document, and we're calling it a template, and I think of it as a reference guide. It's explanatory. It gives some ideas. That's not legal advice either, nor should it be applied in a cookie cutter kind of way. every contract, every deal, every agreement, parties, always different. And so you really do need to consider what the needs are of a particular deal that you're memorializing, and just make sure that whatever you're using reflects that. And if outside counsel should be reviewing that, that's something you ought to do. I'll say I'm consistently impressed by the business owners that we work with who educate us about some of these contract provisions. The substance of some of these terms really is industry specific, and you all tend to be the subject matter experts on that front. So many of you are well equipped to be working through these contracts and highlighting the pitfalls or the things that you like a certain way. And so just encourage you all to keep doing that and keep taking that approach as you work through your deals. And then, of course, engaging whatever outside help makes sense under the circumstances. So with that, allow me to please attempt to share my screen with you. Hopefully, Patrick Dunleavy can confirm with me if I've done this correctly. We're seeing a document?
Yes, looks good.
All right, great. I can tell you I've just not long ago ran a deposition remotely like this, and that was the thing I had to say a lot. Are we seeing a document here? It's not nearly as smooth as just handing a document over to a witness on the table. But all right, so we've come up with a sort of quippy name here, Anatomy of a Contract. And that really was the concept here. It's like, let's just talk about the parts of this thing and what they mean. And I'm certainly not going to read all of this to you, but I will, just for your viewing experience, the bold italicized portions of this talk about what the provision means. It's just sort of commentary about why this exists and what it does. And then there are highlights throughout where it refers to a hypothetical party. And that's a thing that would, of course, be changed depending on the terms of the agreement. See, we even disclaimed you right here in our little document. But and I do a big tip of the hat to Patrick Dunleavy as the chair of the committee, and the others on the committee, as well as Vaughn Clemens, instrumental in getting this done. And so certainly, if you all have questions about this document, you can direct them to Patrick D. and Vaughn. So we just kind of, I don't think I'll touch on every provision. I don't know if you've ever been to a presentation where they just read the PowerPoint at you, but that's tough. I guess a little boring after a while. So just high level comments for you all. But, the very beginning of this, and by the way, the format is going to look wonky because of the commentary. So you'll see where my cursor, if you see, it's broken up. These provisions are broken up so that there's commentary. Agreement's never going to look like this, where it's got all this red going on in between. So it's very long. You'll see it's 20 pages or something like that. Once you took all of that out, I think it's probably half that length, if that. But this is a good illustration at the beginning where you've heard the phrase like boilerplate. And that just is like stuff you find in every contract and doesn't get a lot of thought. And that concept exists, and boilerplate is real. But I do think it's worth keeping in mind that everything that's written in a contract should have meaning, independent meaning. There should be nothing in there that just snuck in as like, oh, that's an artifact of an old deal, or we just always kind of have that in there. That's not a thing. That should not exist. Nor should they be redundant or repetitive. That's like a classic contract drafting mistake, is saying the same thing more than once where you don't have to, because you introduce, Patrick D mentioned ambiguity. That sometimes ambiguity in a contract is okay. The parties would just as well leave some room to decide what things mean as they work through the deal. But most of the time, you want clarity. You want it to be very precise. There's a playbook. It's a roadmap. We want to know exactly where it's taking us. And so stating the same thing more than one time just introduces the risk that, well, you said it this way in provision A, but in provision B, you said it a different way. Well, what does it mean? So this introduction section, I don't think is a risky thing or anything like that, but it's an opportunity for you to say who everyone is and why you're agreeing, and just say exactly what the purpose of this agreement is. that's helpful at the back end if you ever had to argue about what the scope of the contract was, for example. Definitions. Okay, this one is it is really crucial. I'm a big believer in defining things, and like this is like a way that lawyers, I think, get beaten up, rightfully so, out in the just day-to-day life, about how everything's got to be defined, and it's like parentheses, and spelled out 20, and then in parens 20, and it kind of gets ridiculous after a while. But I will say, you're going to spare yourself a lot of heartache in ensuring that terms are well defined and then they are consistently used throughout the document in the same way. So don't define something and then talk about it another way. And we see that. And even in well-meaning contracts drafted by very competent parties, it just happens, especially if you're using them over and over again. They don't line up correctly. So just taking a look to see, well, does this actually define what I meant? Does it describe the party who should or shouldn't be doing the thing? So getting definitions on the table is really important. You will also see throughout this document these like note sections. Like we said at the beginning, when I was trying to lawyer my way out of committing to anything on this, is that not every term, not every provision is going to apply to every agreement. It's a perfect example. Defining remarketing services in 1.4 of the definitions. Not every agreement is going to entail remarketing. I think a great many of you probably don't do remarketing. That's a whole separate thing. So that, like I say, you can't just copy and paste in any agreement, and you certainly can't use this document as just okay, I'll just change the names and then I'll let it fly. That won't work. And I encourage you all to take a closer look at your documents to make sure of that. Nothing wrong with, by the way, having a list of preferred provisions. If you got language you like, hang on to that, but just make sure it applies to your situation. This relationship of the parties bit, that's fairly standard. Again, we're describing the sort of the what of the agreement, and this is the who to follow. So what is the scope? Who's involved? And it's important. I'm quite sure that you all have vendors that you don't want described as your employees, for example. They're contractors of yours. You don't want to take on the obligations having an employee. This is not to be overlooked. Yeah. Duties section talking about, well, I mean, you probably guessed it, but what do you all need to do under this agreement? What's the expectation? What are you committing to? And this is common conversation that we have when we do sort of outside general counsel reviews of these agreements is, all right, it's written down what you've committed to doing. Can you do it? Are you capable of meeting these requirements? Because sometimes I fear that there's well, sign this and then we'll figure it out. We'll get there. And that does give me heartburn as an attorney, because the concept here is, well, if you're not in compliance with these requirements, you're in breach as soon as you sign the agreement. And breach is just a fancy way of saying you didn't do what you said you were going to do. And that's obviously a problem. So you don't set yourself up to not succeed by overcommitting at the front end. And that applies to all sorts of, if Mike was here, I'd bring him to the microphone to talk about insurance commitments, for example. I think a lot of times those tend to be pretty uniform, but don't say that you're going to have X number dollar policy if you don't have it. I think that's elementary, but it's just sometimes people don't consider that. They want the business, they're ready to start this relationship, and they just sign and go. And that's a recipe for disaster. You won't like that. Trying to think if there's any other specific terms here that I would call out. These notification provisions you're going to find in other parts of the agreement, so I'll sort of talk about that separately. Your client's duties, or however you're defining either the lien holder, the forwarder, whomever is sending the work to the agent, or conceivably, if you all were the client in a vendor agreement, for example, what are they obligated to do? And this is an opportunity for you to think about, well, what commitments would I like out of my counterpart? What should they be doing for me? And if I was negotiating one of these agreements for my business, the way I would be framing it is, help me help you do my part. So the things I need from you in order to effectively do the things you want from me comes in here. So this is where, client, you're promising to do these things for me so I can actually go and be effective for you. And so it should always be an ask that you're making in service to accomplishing the purpose of the contract in the first place. Right. We've talked at long length about personal property laws in the various states and sort of how to handle that. Pay attention to this, if for no other reason than even if there's not a state statute that tells you what you can and can't do, this is effectively the law as you've created it with your client. So if you're signing up to handle personal property in a particular way, you should probably go ahead and do that, even if there's a statute that says to do something different. And surely if the agreement is inconsistent with a state statute, so if the state statute imposes higher requirements than a contract, well, now you got a problem with your contract. So that's another sort of like signing up for a legal problem if you're not lining those and making sure that they are congruent with one another. Compensation part should maybe be one of the more important ones for you all, is how are you going to get paid? What are the terms of payment? And what are the results, for example, on non-payment from your client? And this is, you can insert, of course, your interest charges and other expenses, those kinds of things. And the sky's the limit. Okay, it's subject only to your imagination and what your client's going to agree to. And I see this a lot. So one of the most common contracts I negotiate are settlement agreements in litigation, which that's just a specific form of contract. Be wary of what you're asking for. It's kind of like a form of the golden rule, because if you're going to ask for it, they might too. So it's a reason why in a lot of my settlement agreements, I don't say, well, if the plaintiff, usually on the defense side, well, if plaintiff fails to comply with the settlement agreement, we can sue to enforce it, and we get our attorney's fees in having to do that. And that's great, fantastic. But if I ask for that, they're going to ask for the same thing. They're going to say, well, if defendant screws this up, we get that. And I'm thinking, oh, what if we stub our toe? I don't know that I want to open up the attorney's fees sort of issue. So it's just worth considering. Do I want this imposed on me in kind? Representations and warranties are different than duties that are imposed by a contract. And a representation and a warranty are actually also different. They're frequently referred to like as the same or interchangeable, but they're not. The key distinction is that a representation is a promise about something that is true now. A warranty is something that will be true in the future. Okay, so representation now, warranty is going forward, and that's distinct. Like I was talking to you before, don't sign up for a commitment that you can't meet right now in terms of the duties you have under the contract. Slightly different if it's a warranty. If you're warranting that something will be true in the future, maybe it doesn't have to be true right now. That's going to be very deal specific, situation specific, but that's why that distinction matters. Oh, look, we wrote that down. That's good. We even underlined it. That's good. All right. Consistency. But it is, this matters in terms of the back end when something goes wrong, and not even necessarily in terms of the agreement between repossessor or agency and lien holder or forwarder, but in the event of litigation. And it really helps all parties to know, what did you all promise about these accounts and about these placements and how you would handle them. And so having everybody very clearly articulate, here's the things that we promise are true and will be true about the accounts and how we'll conduct ourselves, it helps. It helps establish a later playbook. So when litigation arises, one of the initial conversations that gets had, because it's almost always three parties. It's almost always the agent, the forwarder, and the lien holder. And so a conversation occurs to say, okay, well, who sort of is responsible for what happened? Is it everybody? Is it just one of us? How does that align with the agreement? What did we promise that would be true or not, and how we'd conduct ourselves? And then we create a new playbook based on that. It's like a new agreement almost about, okay, based on the contract, how are we going to handle this litigation? And so the clearer you have your representations and warranties, and the duties for that matter, the easier that conversation is. There's nothing worse than having everybody decide that it was not their fault. So it's apparently nobody's fault. Sometimes that's true, by the way. These are just defensible cases. But, with everybody saying it had nothing to do with us, and then we're going, you look at a contract and it's a mess, it's just a lot of work. And you know what it ends up doing? You know who wins in those situations? And this should make you mad. The lawyers. Because the lawyers then just sit down and they have to bill a bunch of time for trying to figure it out. So everybody's just way better off if we have a course of dealing and a playbook already set up. These representations and warranties are a great way to do that. I will also tell you that you do yourself a great service if you have clear expectations outlined for just the status of these repossession files when they come in and how they'll be handled. If you are ever investigated by a regulator, whether it be state or federal, it's very nice because we handle those matters with some frequency, and being able to show a regulator something along the lines of, well, listen, we make sure that these accounts, when they're placed, they're actually in default and there's a present right of possession, or the notices that were supposed to go out went out. And we also represent that we're not going to breach the peace and we're not going to do anything in violation of the law when we perform our repossessions. That is helpful. That is far more compelling if I can show a number of these contracts that all contain those promises, hopefully in conjunction with some policies and procedures you got for actually doing that, than having to just bring in like the principal of your company and have them say these things aloud. That's fine. That's okay. But if we had a document that's existed for a number of years that we actually use and comply with, it's a lot better. It's just more effective. So I think it's enough on reps and warranties. Confidentiality. I'm here to tell you my view of the world is that every case, every regulatory issue for the remainder of my legal career will be a data privacy lawsuit in some way, shape, or form. Okay. Even if it's not the direct claim, there's going to be issues around it. So defining confidentiality obligations is really, really important. You guys are going to get screwed. Every audience member here, whether you're lender, forwarder, agency, other vendor, your procedures and the way you handle confidential information is going to be scrutinized. You can take that to the bank. And so putting together robust agreements about how you're going to do that is really, really important. Indemnification. Stop me if you've ever heard me talk about this. I don't know that we have to do an incredibly deep dive, but that hypothetical where I saw, everybody scatters. You turn on the litigation light and everybody runs for cover. It wasn't our fault. This really is the agreement within the agreement about what we need to do in the event that there's a lawsuit. And these provisions come in a number of forms, and they can impose vastly different obligations on the parties, depending on how they're drafted. So definitely not a one size fits all. I am of the opinion that mutual indemnity provisions they should be tied to the duties under the agreement. What was your job under the agreement? What did you represent and warrant would be the case and how you would conduct yourself? If anybody fell down or stubbed their toe relative to a duty or a representation or warranty that they made, okay, then probably have to step up to the plate and take care of that. I don't think that is terribly controversial. And my sense is that that's getting better out there. I don't know. I'm sure you all can tell me a lot better. You see these agreements with more frequency, but close attention to be paid here because it is possible to sign up for responsibility for everything, even if it wasn't tied to something you said you would or wouldn't do. And it's a tough trap to fall into. I mean, we handle a bunch of this litigation, and it sometimes, under the right circumstances, they can be asking for a lot of money, the bad guys, and it can be very expensive to defend. And so it's kind of insult to injury if you end up having to indemnify other parties for conduct that you didn't do or not do. So definitely worth watching. I kind of talked to you about the insurance bit. I encourage you, whoever your insurance broker is, your agent or your carrier, whatever your relationship is, I think it makes a lot of sense just to be showing them these provisions to make sure that they line up, that they're covered. I do this just so for like my homeowner's policy and all the rest. I make sure they all talk to each other because some of them have certain like threshold requirements before a secondary layer will kick in. And I mean, in theory, I'm supposed to know how to read these things just like you all do too. But you should contact a professional and just get their opinion to make sure that that box is checked. And I think all the clients on this call would appreciate you doing that as well. That's a tough surprise too. You get caught in litigation only to find out there's no coverage. That's injury to injury. That's not even insult to injury. That's just injury to injury. Notices. This part's important too, because this requires sometimes you to tell your counterpart about things that happen. So for instance, a lawsuit. What if you get sued and you're the agent, say, but they don't name the lien? You might still have an obligation to tell the lien holder that. And it may be spelled out in your agreement specifically to whom you have to make the notice and when. And so that all matters. I'm actually going to take this as an opportunity to do a quick public service announcement as well regarding notice. So our firm does a lot of this litigation. Like I said, we're acting as national counsel for one of the carriers that insures a lot of this industry for certain types of these matters. And I promised I would mention this issue. I can never tell you whether you should or shouldn't tender a claim to your insurance carrier. Just so you all know, there's no good answer to that as a lawyer, okay? Because either I tell you, yeah, oh yeah, you better tender that, and then you call me a year later and like, Patrick, my rates went through the roof, man. Or worse, they dropped me, because I created this bad loss run. Like, oh, sorry. But alternatively, I tell you, it's not that big a deal. It'll resolve quickly. It's not gonna be a problem. We'll get it settled for less than your deductible. Don't tender it. And then it explodes into like the worst lawsuit we've ever seen. And you call it, Patrick, my we're going out of business. We didn't have enough money to fund this thing. So it's just there's no great answer. What you do need to keep in mind is the existence of an insurance policy. You should be aware of that and be prepared to make an informed business decision about whether to do it. And if you reach the conclusion that, yes, I'm going to tender this to my carrier, you need to get that notice to them as soon as possible. So we've witnessed some drag. Okay, so you get served, and I think you all maybe know this, but like the clock starts ticking for when you have to answer the complaint, respond to it as soon as you're served. And it's short. I mean, it's 21 days in a lot of places. It's as much as 30 in other places. That's not a lot of time, especially if your insurance carrier needs to like look at the complaint and figure out whether they're going to give you coverage and if they're going to assign it to counsel and all that. So it just becomes really, really crunched in terms of the timing. So the faster you can tender it, the better off everybody is. Even, by the way, if the answer is going to be, oh, hey, tough bounce, there is no coverage. In fact, I'd almost say in that instance, it's more important because you might have to then hire private counsel, and that's going to take longer. So anyway, the faster, the better. Time is of the essence on that. So if you decide you're going to tender it, do it right away. Do not delay. I'm not going to talk about that. Term and termination, I like. Y'all should have really clear ability to get in and out of these agreements. Okay, you can get stuck with an agreement that's really not good for you if you don't look at the term part of it. So don't sign up for a 5-year deal or something that automatically renews unless you're aware of it and you're good with that. Nothing worse than getting stuck with a non-performing or unprofitable deal that you have to keep doing. Okay, miscellaneous. This is a lot of lawyery stuff. This is that boilerplate, but it does matter. You should read it. You should know what it means. I'll pick out a couple. It's like a non-waiver provision here at 14.2, meaning just because we do certain things under this agreement doesn't mean that we're giving away any of our rights, okay? We maintain the ability to do anything it says under this agreement or under the law, okay? You can't say that we waive some ability to do something else. No amendments. This is important. That means that you all can't just, this is 14.4, y'all can't just talk and decide you're going to change the way you do things. If you want it to be binding and effective, got to write that down and everybody has to sign it. In this particular instance, your amendment has to reference this agreement specifically. So, and this happens. I mean, it's amazing the deals that get done on a handshake. And I think there are some folks out there who just feel like, oh, if I ask for a contract, I'm going to offend somebody, or if I tell them we got to, I would hope that you all can sort of delete that from your minds and just, if it's not written down, it doesn't count. It's not real. That's how this goes. And I would hate for anybody to get bit because even if you have an email, even if you got an email that says, hey, we're going to change this, that's maybe not going to be effective under this agreement. So the details matter. Oh, yeah. There's this old doctrine. This is the only contract doctrine that I'll say to you today, I promise. 14.6, Latin. Ready? Brace yourself. Contra preferentum is a silly way to say that whoever drafted the contract will have the terms interpreted against them. Meaning, if there's ambiguity, we're going to interpret it against whoever drafted it and in favor of the party that didn't. So we're going to give a break to the person who didn't draft it because we assume that the drafting party knew what they were up to and they were in a better position to decide what it should mean. Okay. This gets rid of that. That's the standard kind of rule, but this does away with that. That says, nope, we all drafted it. Everybody had drafted it. We knew what was going on. We negotiated it. So nobody is getting the benefit of the doubt. This contract says what it says. If there's ambiguity, well, we're going to have to lawsuit each other over it. Let's see. Oh, sure. Y'all ever acquire a business or merge with a business? Y'all should get your hands on the agreements that were signed by your predecessor to see, did anybody agree to be bound later? And you need to figure out whether that applies as to you. That's why that matters. State law, big time. The laws of the states are very different, very different. And which states' laws are going to apply in terms of interpreting a contract, arguing about it, having a fight over it. So pay attention to that. There's also what's called a venue clause. I don't know if this one contains one, but I don't think we put one. Let's see. Oh, yeah, it does. It's right there. It's in black and white. It tells you where we can bring suit. Okay. So if you're in San Diego, California, it's going to be a little inconvenient for you if any lawsuit has to be venued in Atlanta, Georgia. That's a long flight. So think about that. Just be aware of it. Sometimes it's not movable. If you're dealing with a large institutional counterparty, they're going to put the venue provision where they're headquartered because they want to be able to walk down the street to the courthouse and use their local lawyers. There might not be a lot you can do about it, but you should at least be aware of it. This last bit right here, also important. Stock standard, but it does matter. It's called a merger clause. And essentially it means we might have had other agreements. We might have talked about stuff. We might have proposed things, handshake, napkin, whatever it was, emails. None of that matters. If it ain't in this contract, it doesn't count. We're doing away with all of that. And the only way you can change it is by the amendment provision described above. Really important. Keep that in mind as you're negotiating. I don't think I have to talk about signature blocks. We did a little bit of a speed run there. I hope I didn't bore anybody to tears. Did we get any audience questions?
We do. We've got a couple of questions.
Sweet.
Um, we'll start from the top. So Mark Griffin, for the indemnification section, the client section contains quote unquote grossly negligent, but the repossessor section omits grossly. Shouldn't the language mirror each other? And
That would
there's
be,
more to the question, but we can start there.
yes, that would be preferable. Did we include that in our draft? That's a good red line that we should, I'm just looking at it. I'm reading a contract in real time. I know how to use Control F. Yes, I agree with that. Yes, that would be an instance of not true mutuality of provisions. So thank you for that. That's a sharp eye, Mark. I agree with that.
Also, in the same section, do you see any utility in adding specific language around the client's obligation to indemnify in the cases where repossession orders are alleged to be invalid because the lender did not have a valid security interest in the vehicle?
So I've seen it both ways, and this is sort of a preference where we talked about, this is one instance of would you prefer broad terminology or very specific? I think if it is worded correctly enough, and I'm not broadly enough, I should say, that it is going to encapsulate that circumstance without specifically saying it. I'm not telling you whether this example that we've given you does that, but it's a preference. Certainly, if you think that that's the most likely case in which you're going to make an indemnity request, you might call it out specifically as part of a very broad provision. So something along the lines of including without limitation the example you just gave. That probably works. It'll take some wordsmithing, and it's a point of preference. Oh, Tony, you're on mute.
Thank you. From Vaughn, our fearless leader. Patrick, what are your thoughts on national contracts in our industry that impose uniform fee schedules across vastly different markets like California and Texas, where the cost of doing business, regulatory burdens, and operational expenses vary significantly?
I think it
That's
touches
part
on
one.
one of the. Oh, it's a two-parter. We got a multi-part question. You should tell
Yep.
Vaughn you get one question per president. So um, this highlights one of the things I think I said earlier, which is a key theme here, is that no agreement is a one size fits all deal. Now, whether one party to the agreement would like it to be is another question, but I think that matters. I mean, use lawyers, for example. You know, a fancy LA lawyer is charging a lot more than, I'm going to say a city and I'm going to offend somebody. So I love Cleveland, but just pick Cleveland. You know, it's going to be a different rate. Okay. The cost of living is different. The expectations for the market are different. That's just how it works.
Because
And
nobody
so,
wants to be here, Patrick.
see, I knew it.
Yep.
I tried to pick somewhere. It popped into my head. Love Cleveland. Do you know that if you fly over the Milwaukee airport, there's a guy who wrote on his, is right in the path of the runway. It says on his roof, "Welcome to Cleveland." That's great. It's a great joke. That's a lot of effort for very little payoff, but I appreciate it. So I do think it's a valid concern and something you should be thinking about when you're negotiating these contracts. And I think it's a valid point to discuss, to say, I'm in Cleveland, so my costs are higher than Minneapolis, St. Paul. So yes, I think it's worth discussing.
Yeah, I would just chime in too that I think that there's been a lot of national clients who have been open to those discussions, and will include some considerations in some of those fee schedules in those tough markets, right? And that's definitely a conversation that I think it can't hurt to ask. And thank you to those clients who have expressed some concern and consideration regarding that.
No question about it. And so I walk around this law firm with a bunch of ideas all the time, and just, go to our board of directors and say this, that, or the other thing. And a lot of times what I get, and rightfully so, is that's great, Patrick, you have a strong feeling about this, but do you have anything to like support that data wise? So it would be my suggestion, and this is more of a business kind of thing, and you all are good business owners, but what can you do to support the ask? Show the data, support what you're saying. Anecdotal sort of stories about, inflation hurting us too is not probably as compelling as showing actual surveys of what the cost of living is.
And if we need to, we can, get on a conference call with Jeremy Cross and he can help you put those figures together.
Kind of a data guy, isn't he?
Yeah.
So, I heard this was a two-parter. So Vaughn's violated the rule that I just announced, but okay, go ahead.
So part 2 is, how do you think we can address the challenges that arise when agents in high-cost states are undervalued while those in lower-cost states are overcompensated? And what solutions would you propose to ensure a fair and sustainable fee structure?
I think that, everybody needs to, so this is an association and which does a great job of looking out for members and highlighting the issues. But you all are all your own business owners. And so there can't be, there's no overarching thing I can say that everybody should be doing together. It's recognize what the value of your service is, support that, and make the asks. And like any industry, there are always going to be the folks who maybe will race to the bottom, to take the lower fee just to get the work. My experience is that those folks tend to escort themselves out of the marketplace relatively quickly. And so here to put it, this is an old one, but you can be the best or you can be the cheapest, but you can't be both. My suggestion is that you focus on being the best. And you've heard me say this before, and I'm pretty sure that leadership at the ARA endorses this viewpoint. You all have to view yourselves as compliance professionals, okay? You're not just, nobody's cowboy, cowgirl out there anymore. That doesn't work. You're not just running around doing things without thinking about it. You're professionals. You're providing service in a highly regulated, very dangerous environment, and you should be paid accordingly. And in order to get that pay, you need to demonstrate that level of competence and that level of value. So support it, support the ask. And you should all do that. And as business owners, if you're not comfortable doing that, you got to find a way to be comfortable.
Okay. Vaughn's been busy in the Q&A box. So here's another question from Vaughn. Why do national contracts require agents to carry workers' compensation coverage for clients and forwarders, even though these entities do not directly employ the agents or their staff?
That's like a quasi Mike Poplinski question. So this is sort of informed speculation. If I'm really candid with you, the work comp, so you all know more, you've forgotten more about work comp than I will ever know. Okay. But my off the cuff thought is, if we have some kind of like an accident, an auto accident is what jumps out at me, is a thing that would be the most common that would happen. And what if agent is driving and is catastrophically injured, and your agency who employs them is underinsured? Even if it's not supported by the work comp structure, it's easy for me to conceive of a situation where the injured driver would then look to the lien holder or the forwarder or whomever to say, I was actually acting as your employee too. And so I think you need to cough in whatever your work comp insurance covers. And again, whether any of that works or is valid is a totally separate question. But I mean, if I'm advising a business that's involved in any way in a highly regulated industry and that has any, even remote possibility of bad workplace injuries, I'm going to have an interest in everybody being well insured. And I know that's a cost, by the way. That's not lost on me. Okay. It's a significant thing. And that just goes back to the earlier point. Okay. There may be folks out there who are able to secure the work without being properly insured. And, they're getting the work off of your back because they're doing it without a cost. Okay. And maybe that allows them to take less in fees. Again, differentiating ourselves. Those are not top tier service providers. That's got to be our focus so that you got to focus on the revenue piece of this, not as much on the cost. I know the costs are real. We have them too, by the way. A law firm is a business, believe it or not. So I'm very, that's on my mind, but focus on getting the revenue to where it belongs. I think that's the better push.
Okay, when you encounter a contract that does not allow for red lines, should you raise a red flag? What are your thoughts on an industry locked into take it or leave it agreements? And how does this impact fairness, negotiation power, and long-term sustainability for agents?
Yeah, this is not a unique phenomenon just to the repossession industry. Every day, I think all of us, someone on this call signs a take it or leave it agreement in some context. Is very difficult. It is dependent on the terms. If you have these very onerous obligations and the choice is, well, take them or don't get the work, that's hard, especially if I'm a sort of fledgling repossession agency, or I just had a huge direct contract leave me, so I need this one. And so some of this is risk tolerance, one thing. And a second is being able to stop me if I keep relying on this kind of crutch, but being able to position yourself as a top tier, best in class service provider starts to allow you to say no to the work, because that really is your leverage. If their position is this is it, take it or leave it, your only leverage is to say I'm going to leave it, and that cannot be idle. I don't think that's not effective. I don't know if you've ever made an idle threat in a negotiation and get called on it. It's pretty silly. And so mean it is my advice, and walk if you can. Not everyone has that luxury, and I know I'm making very simple what is a very complex situation. But as I say, I worry about the folks who sign up because they don't have another choice. You are potentially making a deal that could be the end of you 2 years down the line because something goes sideways and you agreed to something you can't do or you can't sustain. So yeah, be best in class. So you have enough work and the luxury of being able to say, I'm not going to do it.
Okay, from Steve Brown, do we have any hope or have there been any conversations in getting the national forwarders we all work with to accept this template?
I don't know. And I have to be, just so everyone's clear again, like none of this can be like a collective kind of thing. This is a reference document. And so is not designed in any way, like I said before, for y'all to just like take and then send to all of your people and say, hey, agree to my agreement. That's not the point. The point is that it's as if a Wikipedia page existed for a template agreement that explains what's going on. And it's so something to look at. In fact, I'll tell you this too. I actually did have an effective contracts class later in my law school experience. And one of the things that the professor told us is like, this is the one area in the law where you should be plagiarizing the other people's work. Go find agreements that you like and that make sense to you, the provisions that you like, and take that provision and incorporate it into yours. Okay. And that, assuming you all have the wherewithal to assess whether it's good or not, and if you're working with counsel, I think even the better for you. That's what you should be doing. So yeah, nobody here should be like calling their friends up in the industry and be like, okay, we all got to get this template out there, and we're cramming it down people. So do not do that. That's not the point of this at all. And so I do think you should use this resource and any others available to you to vet the agreements you are getting in as proposed to you, and think to yourself, does this line up with what I would expect in a contract that I think is objectively balanced to both sides? And by the way, there are folks who may look at this template agreement we're calling it, anatomy of a contract. We really shouldn't call it a template, because nobody should be just plug and playing it. It's more of a description example agreement. There are folks who may look at that and be like, that's not balanced. Mark Griffin already pointed out that we goofed up on the grossly negligent part, rightfully so. And so there may be other aspects of that. So it's really for you to understand, to be educated, and then to respond to agreements, or if you have agreements in-house that you like, to just consider them and think, does this get me where I want to go? So I don't think, I just kind of reject the premise of the question that there would be a national, like, okay, here's the repossessor contract. That's not a course really that should be taken.
Mark Griffin had a follow-up question. I might have, this is what he said, I might have missed it in the run-through, but is there a section on the template that talks about stolen collateral from the repossession's control, or repossessor's control, pardon me? From the ARA's perspective, would it be beneficial to have the language in the template that, number one, limits financial liability to the ACV and not the outstanding loan? Two, allowing the repossessor time to relocate the vehicle. Three, absolving repossessor liability completely if it is reasonably shown that the debtor stole the vehicle. And four, putting an affirmative duty on the lender to notify the repossessor if it has information on the vehicle's whereabouts, e.g. impounds.
So okay, so Mark is a person who has thought a lot about these provisions. And so I applaud the thought process. And the purpose of this document, again, it's educational. And so it's not going to have, like, everything that was described in there, at least conceivably, could go into an agreement. And there might be very good reason to insert that kind of language into an agreement. Okay. So this example is not complete. It does not have every term, it does not have every instance in it that we might be able to come up with as a group. But what was just outlined is certainly I could envision a benefit to all of that. The circumstances of the theft and all of that. Yes, I do think those are things you should think about. And if they make sense and you have a counterparty who is willing to have that conversation and negotiate, then by all means. And that goes for every term that isn't in this example. Is yes, if you think that there's a different way, a lever that can be pulled or a dial that can be turned in a different direction, consider doing that. Absolutely.
Okay, I think that is the last question. Anybody else have any questions before we turn it back over to Patrick Dunleavy to close us out? Doesn't look like it. Yeah, I think that's it. Patrick Newman, thank you, sir.
Thank you, guys. I hope it was
educational as always.
Yeah, just also to note,
Definitely helpful.
You know, the contract is available by request if you want to send a request into the Contracts and Insurance Committee email address. And we're also working on posting that up on the repo.org ARA page as well.
Patrick, what is that email address?
Let me see if I can just copy paste it and maybe put it in the chat. Be easiest. There you go.
Contract-insurance at AmericanRecoveryASSN.org. Perfect. There you go. Yeah, everybody, we are working on getting that template uploaded to the member resources section of the ARA website. as soon as that's done, we will let the ARA membership know that it's available. Okay, well, everybody, thank you. It is, we're going to give you 5 minutes back. Just one last note, the NARS early bird registration for exhibitors and for attendees is open. There are still a few sponsorship positions or opportunities available. So go to reposummit.com. That's reposummit.com. I'll type it in the chat. And get registered. So we will see you next month, and be on the lookout for notification. We'll be sending out some details about next month's webinar, and it's actually going to be earlier in the month. I believe it's November 7th. Don't hold me to that, but it is definitely earlier in the month. So be on the lookout. We'll be sending that out probably in the next within the next week. Okay, everybody, have a great day. Patrick, thank you, sirs.
Thank you.
Thank you.
Bye, guys.